Hello and welcome to Talks on Law. I'm Joel Cohen. Today we're going to be talking about suing gun manufacturers and civil immunity for those same manufacturers. We have an expert on the Second Amendment joining us today. Professor Jody Madeira teaches at Indiana Bloomington School of Law. Jody, welcome back.
Thank you so much.
Well, today we're talking about suing gun makers. I guess first off, am I right to say that this really isn't a Second Amendment issue?
It is a Second Amendment issue, but only so far in that some have asserted that firearms manufacturers, distributors, retailers, those who perform those services for component parts, ammunition, trade organizations, etc., because that industry basically is there and it's connected to a fundamental constitutional protection. It's critical to exercising the Second Amendment right. So some have justified civil immunity for the industry on that basis.
So in order to keep and bear arms, we may need a right to manufacture them.
Yeah, exactly. Yes.
All right, so maybe we can talk about the immunity. This is something that most of our viewers may not be familiar with. There's a specific law that was passed to protect gun manufacturers from at least some of the misdeeds of their purchasers.
Yes. So in the 1990s, there was a large number of lawsuits that people were bringing, mostly cities like Philadelphia, Chicago, Gary, Indiana, etc. And basically, they alleged that firearms, guns were a public nuisance. They were connected to drug crimes. They were connected to basically exorbitant law enforcement costs. And in response, the firearms industry lobbied Congress basically around 2004, 2005 for immunity. And they argued that, well, we're being sued for things that aren't really our fault. They're not our fault. They're the shooter, the fault of the person who actually pulls the trigger, that this criminal third party. And so Congress responded with the Federal Protection of Lawful Commerce and Arms Act in 2005. That's codified at 15 U.S.C. section 7901 to 7903. And basically from start to finish, it took 8 months before George W. Bush signed it into law.
The fast track.
Yes. Oh, for sure. And there are arguments that Congress never before granted an industry such extensive legal protection. And again, there's that, Second Amendment argument that's why we need to shield firearm and ammunition manufacturers, dealers, and other industry stakeholders. So what PLCAA, the Protection of Lawful Commerce and Arms Act, does is it basically prevents the plaintiffs from bringing certain types of lawsuits against industry defendants. And we're talking basically here about lawsuits for damages brought by a person, like a victim who's shot, or a government entity, for harm resulting from the criminal or unlawful misuse of firearms or ammunition or components by a third party. And so there are a number of exceptions to this law. For example, if you transfer a firearm to someone knowing it is going to be used to commit a violent crime, that's a problem. That's an exception. There's exceptions for negligent entrustment. There's an exception known as the predicate exception, which is the most important one, where a manufacturer knowingly violates a state or federal statute that's applicable to product, sale, or marketing. So basically, they make false claims, for example, that tie your firearm too closely to military purposes when it's a civilian weapon. There is an exception for breach of contract or warranty in connection with the purchase of a firearm or a firearm-related component. There is an exception for products liability, death, injury, property damage resulting from a defect in design or manufacturing when the firearm is used in an intended or foreseeable manner. These kinds of cases are, well, the gun's going off despite the fact that I didn't depress the trigger, for example.
Sure. Or I had the safety on and it still shot.
Exactly. And there's any action commenced by the Attorney General to enforce the Gun Control Act or National Firearms Act.
Maybe we can talk quickly about negligent entrustment. There was an interesting case in 2015 involving the deaths of a couple of police officers. Maybe you could share some details there and how that bears on negligent entrustment.
Sure. So negligent entrustment is also basically parallel to another issue, which is the unlawful sale of a firearm or a straw purchase. And so in the Badger Guns case, which took place in Milwaukee, Wisconsin, Badger Guns was sued by police officers who were shot through by a firearm that was largely sold to a felon who never should have possessed a firearm to begin with. And Badger Guns allegedly sold this firearm to the felon through a straw purchase. In other words, they sold it to a person who legitimately could buy a firearm, who then turned around and gave or provided it to the felon. And so here, Badger Guns was liable to the police officers in a jury verdict, and the case subsequently settled for about $1 million.
That seems like a bit of an ask as well, because I mean, it could be, as an individual citizen, maybe I want to have 75 guns, and then I drive them down and sell them at a gun show in Florida, and in many states that is lawful. So how are they supposed to distinguish between a straw purchaser with nefarious intent and someone who's perhaps a dealer?
That's great. And there have been a lot of training that has been provided to federally licensed firearms dealers over the years. And so, for example, the ATF or others will basically say, well, look for some things that are suspicious. So if two people walk into a gun store together and one seems to be directing the attention of the other towards particular firearms and seems to be the one handling the firearms, asking to see the firearms, but yet the other person buys the firearm. And so that's one very clear analysis. The other is, of course, you see two people buying a firearm, and again, they're pretty actively engaged. Both parties are pretty actively engaged, but only one comes back and buys the firearm at a later time.
And then perhaps does that multiple times.
Exactly. Yes.
Perhaps a step up in level of, I don't know, culpability on behalf of the gun seller would be actual knowledge that the person was going to use it for a bad deed. Is there case law on that?
Yes. And actually, again, that is an exception to PLCAA. Now, it's interesting because PLCAA hasn't really been used in that context very much. Again, most of litigation is under the predicate exception, but there's a lot of state immunity statutes as well that sort of provide a second layer of protection for the firearms industry beyond PLCAA. And so it's on that level that actually the knowing transfer of firearm has really come up. And for example, in Indiana, the Indiana immunity statute is so strict that in a case that mirrored Badger Guns, actually, where there was an illegal sale to a felon, and a police officer was later shot by that same gun, by that same felon. Basically, this Indiana Supreme Court said, even if a retailer knowingly sells a firearm to someone who, for example, wants to shoot up an elementary school, the victims of the students killed could never come back and sue that firearms retailer because the immunity statute is that comprehensive. So at that point, that's one of the strictest in the country, if not the strictest. And I think we're looking at immunizing unlawful conduct at that point, which is actually going far beyond PLCAA.
Wow. So you're saying that some states take the immunity of gun manufacturers further?
Yes, even further. And for example, two states, Arkansas and again Indiana, force victims who file suit against a firearms manufacturer, alleging negligence or alleging violation of some PLCAA-like claim, to pay the defendant's legal fees and costs if they lose. And so this is interesting because if the industry loses and the victims win, the industry doesn't have to pay the victims expenses. And there was actually a Colorado couple, the Phillips. They had sued an online retailer, Lucky Gunner, after the Aurora, Colorado shooting. And they alleged that the internet retailer basically sold thousands of rounds of ammunition and a 100 capacity magazine to the shooter without providing reasonable safeguards to prevent dangerous people from getting weapons. But this case was dismissed under PLCAA, and the couple was ordered to pay the shooter over $200,000 in legal fees, which bankrupted them.
They had to pay the manufacturer?
Yes, they had to reimburse the manufacturer for their legal fees. Yes.
Wow. All right. So not only do they have immunity, but they have this sort of, I don't want to say punitive, but discouraging protection where the legal fees are also thrown in.
Absolutely. Yes. And it's there to discourage any lawsuit to begin with.
We've been talking about knowledge in terms of selling to someone who you know or you have reasonable belief that someone is up to no good. But the manufacturer and the seller, are those often the same people? Are we talking about D2C sales, or are there gun shops in between?
So you have lawsuits like that, for example, in Gary, Indiana, where Gary alleged that there were gun manufacturers that basically violated the state's public nuisance laws by irresponsibly marketing guns and selling guns to gun retailers, to federally licensed firearms dealers, um, in ways that should have been obvious were not compatible with legitimate transactions. So, for example, the gun shop would say, "Hey, my inventory is cleaned out." One person came in and bought 100 firearms in one fell swoop,
Mm.
and then these firearms start turning up, in various criminal incidents in, Indiana and Illinois and other states. They become part of the iron pipeline, and that lasts from Canada down to Mexico. And so we start seeing them show up in illegal transactions. And so basically, we see these connections to gun trafficking.
It's kind of giving correlations to what we saw in the opioid cases, where if a certain pain clinic was shipping 10x or 100x the amount of pills, maybe these pharma companies should have known better.
Absolutely. Yes, definitely.
Well, let's talk about marketing, Jody. That was an interesting aspect of the law, and that's been one that's been actively litigated. In fact, there was a recent case involving a school shooting where a parent was actually successful, or was a class action, was successful in suing. Maybe you could share a bit about this 2022 case.
Sure. So in February 22, the Sandy Hook settlement came down, and this was an unprecedented $73 million settlement that was actually paid by Remington Arms. Remington had made the Bushmaster XM15 E2S rifle that Adam Lanza had used in the Sandy Hook shooting, where several heartbreaking murders occurred. And basically, the parents of these murdered children had alleged that Remington had violated state law, like Connecticut's Unfair Trade Practices Act, by knowingly promoting and marketing the Bushmaster rifle for use essentially in assaults against human beings. And so the Connecticut law required them to prove that they marketed the firearm in an unethical, oppressive, immoral, or unscrupulous manner. And so they built this case that, you had phrases like, restore your man card, get your man card back.
Consider your man card reissued.
Yes, exactly. Consider your man card reissued was the marketing phrase they used. And it was, again, this very, couch commando appealing phrase where they suggested that this firearm could restore masculinity that purchasers might feel they were lacking in other areas of their lives.
You mentioned the predicate exception. Maybe could you build that out a little bit? What is it? What is that referring to?
Sure. So the predicate exception is, again, an action. It's an exception to PLCAA where the plaintiff alleges that a manufacturer or seller knowingly violated a state or federal statute that is applicable to product sale or marketing. And that violation has to be the proximate cause of the harm on which they seek relief. And so, for example, in Sandy Hook, the plaintiffs alleged that Remington's marketing practices violated a Connecticut trade practices statute, and that was a proximate cause of the shooting because Adam Lanza was enticed to use that firearm by the marketing campaign.
I'd be very curious your thoughts, but it seems to me that argument wasn't predestined to win, and I could imagine, certainly in certain states or under certain courts, it not being a successful one. Were you surprised by that outcome?
I was, but also there's several sort of unique features of that case. So, for example, Remington was in bankruptcy at the time, and the bankruptcy trustees had a lot to say in support of the settlement. And so we're not sure if this was just a healthy firearm manufacturer that was not in bankruptcy, what they would have done. Would they have taken it to
Interesting.
trial? That kind of thing. And in addition, this was a very, very high profile mass shooting, probably the
Horrible.
most high profile. And so again, the deaths of elementary school children. And I think you could make an argument that Remington was more likely to settle just to get this out of the news and to move on. And the other thing too, the final thing is obviously it's a settlement. And so it could, the jury verdict could have come back higher. But then again, the plaintiffs would have had to be held to their burden of proof at that point in a trial.
Professor Jody Madeira teaches at Indiana Bloomington School of Law. Jody, thanks as always for your time.
Thank you so much. Have a great day.